Hi, everyone. Once again, it's Brian Festa, Vice President and co-founder of We the Patriots USA. Check us out at wethepatriotsusa.org. Back here again today for take two. We're going to try this again. Yesterday, I recorded a rather lengthy video. I'm going to try to make today shorter. Unfortunately, the audio was distorted because for whatever reason, StreamYard, the program we use, defaults to my computer microphone rather than the go again. It disconnected. So hopefully this doesn't keep happening. If it does, I'm just going to have to record on a different program or use something else. I'm not sure exactly what the issue is here. Maybe by selecting that, it'll be a little bit better. But I'm going to keep an eye on it and make sure the microphone stays connected. I want to talk about MAHA, Make America Healthy Again, the movement begun by President Trump and HHS Secretary Robert F. Kennedy Jr. As everybody knows by now, President Trump, during his campaign, towards the conclusion of his campaign, his last presidential campaign, brought in RFK Jr. To launch the Make America Healthy Again campaign for America. And a lot of good has been done. I'm not here to trash the good work that they've done or to bash it. I think that some amazing things have happened at the federal level that I personally didn't think I would see in my lifetime. So I'm really, really excited about that. But with regard to vaccines, in particular, religious exemptions for vaccinations for school children, there's a lot of people in Health Freedom that have been very disappointed and have been asking me, hey, what's your opinion on this or that that's happened, particularly just within the last month. Really, today's June 4th. So since exactly 1 month, May 4th is the first document I'm going to talk about, a letter from RFK Jr. to Congressman Greg Steube of Florida in response to his request for the Trump administration to do something about religious discrimination with regard to vaccine mandates for school children. And RFK Jr. sent a letter in response dated May 4th. So I'm going to look at that first. Then I'm going to talk about a brief filed by the U.S. Solicitor General just a couple of weeks ago, maybe not even 2 weeks ago, maybe just a week and a half ago, in a case that was challenging the New York healthcare workers mandate, Kathy Hochul and the New York Department of Health's healthcare worker COVID shot mandate from 2021. It's finally reaching the Supreme Court once again. We had a case initially that reached the Supreme Court. They declined to take up review. Now they're considering once again to take review, but they asked the Solicitor General to weigh in. And the Solicitor General filed a very interesting brief. And then the third thing I'm going to talk about is President Trump's executive order, which actually just was issued on May 29th. So just last week, an executive order regarding the CDC's childhood vaccination schedule. So without further ado, I'm going to get right into it. Before I do, I just want to say, please support Mission 250, because the only way we're able to continue litigating and fighting back in court is with your help, with your support. We are a 100% donor-funded nonprofit. All of our funding comes from public donations. So in order for us to fight back in court, we do need your support, and we're trying to raise $250,000 by our nation's 250th birthday, which is July 4th, 2026. So that's coming up exactly 1 month from today. So please visit our website at wethepatriotsusa.org. You'll see on our homepage, just scroll down a little bit, and you'll see the Mission 250 graphic and the button, which will lead you, if you click on it, directly to the fundraiser. All right, so the first thing I want to talk about is that letter from Robert F. Kennedy Jr. to Congressman Steube, and I'm going to share my screen. Let me see if I can find it here. Had it up just a moment ago. Let me just put that up on there. I apologize. Sometimes I'm a little technically challenged at times. Yeah, here we go. So you should be able to see that now. And you'll see it's dated May 4th, 2026. And it's from Secretary Kennedy to Representative Steube of Florida, is how you pronounce it. And he said, your letter concerns parents who have sincerely held objections to vaccination mandates. You note that in states without exemptions from vaccination requirements, parents and families who object to vaccination are compelled to violate their faith. You request the Trump administration take measures, including issuing an executive order to ensure the protection of civil and religious liberties regarding vaccines. He goes on to say the Department of Health and Human Services' role is to make vaccine recommendations based on the best scientific evidence and to provide public health guidance. With the exception of the department's oversight of the federal Vaccines for Children program, decisions about school vaccine requirements, including exemptions, are made by state and local governments. The department does not have the authority to issue nationwide vaccine requirements for the public, nor does it set or enforce state requirements for school attendance. Talks about some of the other things they have done to try to protect religious liberty and make sure, like the HHS Office of Civil Rights, some things they've done. In particular cases, these are just very selected cases that he cites here, but in general, he's correct. People aren't going to want to hear this. I know people don't want to hear me say this, but in general, he is correct that the federal government does not have the authority. HHS does not have the authority to go into the states and say, this is what your vaccine schedule should be, or you should not mandate any vaccines, or that you must give religious exemptions for every child who asserts one for vaccinations. You would think that because that's in the First Amendment, I know not everybody listening has a legal background or is an attorney, but I know in general, a lot of people think, hey, this is federal law though, isn't it? The First Amendment, the Free Exercise Clause, says that we have freedom of religion. So can't the federal government then enforce the U.S. Constitution, which is the supreme law of the land? That's federal law, right? No. The HHS is not tasked with enforcing or forcing states to adopt certain laws, because then that violates the 10th Amendment. Because if there's not a power, vaccination requirements or rules and regulations regarding vaccination requirements is not a power specifically designated to Congress by the Constitution. And what does the 10th Amendment say? Is that power is not specifically enumerated here, not specifically granted by the people to Congress, to the U.S. government, are reserved to the states or to the people respectively. So the states and the people retain the power. We have a federal government of limited powers. So the federal government really doesn't have the authority to go in and say, this is how your vaccine mandates need to look, or you can't have any mandates, or you have to make this regulation or this law regarding school attendance. You have to allow all religious exemptions. Federal government can't really do that. They can try to restrict funding. Say, if you're not honoring religious liberty, we can withhold some funding. That will be challenged in court very quickly, as have other funding restrictions by the Trump administration been challenged by the attorneys general in these various states like California, New York, Connecticut, Massachusetts, so on and so forth. They're challenged. Usually they are successful in getting a federal judge to issue an injunction to stop the executive order, and then it gets tied up in the courts for however long. Even if the executive order is allowed to stand, once President Trump leaves office and Bobby Kennedy is no longer HHS secretary, what happens when the next president comes in who doesn't agree with President Trump or Bobby Kennedy and decides to repeal everything? Well, then we're back to square one. And then in the meantime, all the good work that organizations like We the Patriots USA have done to get cases to the Supreme Court, because we have one that's literally on the doorstep. It's at the Second Circuit right now, but we're waiting for a decision, and then we'll be appealing to the U.S. Supreme Court if it's not favorable. So we have it's a very, very good case that's on behalf of a Christian school, where the state tried to shut down a Christian school in the state of Connecticut because they continue to honor religious exemption. So it's the state attacking a religious institution. It's a perfect case to get to the Supreme Court. We're right there on the cusp. If suddenly an executive order allowed all children back into school, that case would be likely dismissed as moot. And all the other cases across the country that have been litigating for the last 4 or 5 years or longer that are this close to getting to the Supreme Court and getting a decision to help everyone in the country would be dismissed. And so then when the new president were to come in, if a new president were to come in and undo all that good work, repeal that executive order, suddenly we're back to square one. We have to start those lawsuits all over again. Then it's another 5, 6, 7 years or however till we can get to the Supreme Court. And why is it so important to get to the Supreme Court? Well, because that's a lasting victory. Supreme Court decisions stay on the books usually for decades, if not centuries. Most of the Supreme Court precedent in this country has never been overturned. So you're talking about not only your children, your grandchildren, your great-grandchildren, your great-great-great-grandchildren will be protected by a Supreme Court decision. Executive order doesn't offer that kind of protection. The most protection you're probably going to get is the next, 2.5 years. And that's, maybe the next president comes in and doesn't repeal the executive order. Maybe it's someone, in line with the Trump administration agenda, but we don't know that. Even if it is, that's still only another 4 years, maybe 8 years, not decades or centuries. That's for sure. So we want to get those lasting victories. So Secretary Kennedy is correct there. I mean, again, I hate to say it, and I know it's a letdown to a lot of people. That's not the response they wanted to see to Congressman Stubbe, who's trying to get the federal government to reinstate religious exemptions for these states. But the federal government doesn't have that authority. Okay, they don't have the authority to usurp state law. States have their own rights, and we have a federal government of limited powers. So let's talk about the second thing. The second thing was there's a case right now pending Supreme Court review, which is challenging the New York State COVID shot mandate for healthcare workers that was issued by the state of New York and Governor Hochul back in 2021. We had a case now in the interest of full transparency. Our case is heavily cited in this brief because unfortunately there was a very bad decision, we feel an incorrect decision from the Second Circuit in our case challenging that mandate, and unfortunately has been allowed to stand because the Supreme Court, we were one justice away. We had 3 justices who said they would have taken up our case, but you need 4 to get the case taken up to the Supreme Court. So unfortunately it was Gorsuch, Thomas, and Alito who would have taken our case, and we couldn't get that 4th justice to take up our case. So unfortunately, we did not get Supreme Court review, and that Second Circuit decision, which upheld the COVID shot mandate, which has now since been repealed, that New York healthcare worker mandate, was cited. And so we would love the Supreme Court to revisit this, and they're considering revisiting it right now. But the U.S. Solicitor General steps in. They were asked to weigh in by the Supreme Court. The Solicitor General steps in, the federal government steps in and says, no, don't review it. The Second Circuit decision was correct, leave it alone. And so everybody's like, what's going on here? This is the Trump administration. The Trump DOJ is telling the Supreme Court not to review this COVID shot mandate that was allowed to stand, not to revisit that decision, not to strike down that mandate as unconstitutional. Why? Well, there's a long, convoluted explanation. Legally, on a technical, strict legal basis, nothing they say there is incorrect. If you look at the brief, and I'm not going to go through the whole brief, so I don't even know if I want to pull it up, but I'm not going to because it's long. But if you look at the brief, it talks about Title VII. So Title VII is the federal law. Title VII of the Civil Rights Act of 1964 is the federal law that prohibits workplace discrimination. So discrimination on the basis of race, sex, national origin, color, religion, and so on and so forth. There's a series of protected classes. And so religion is one of them. So religious discrimination in the workplace is prohibited by Title VII. So this New York State healthcare worker mandate, if you recall back in 2021, the state of New York issued a healthcare worker mandate that everybody had to receive the COVID shot who was a healthcare worker, and it only allowed for medical exemptions. It didn't say specifically that there would be no religious accommodations allowed, and that's how they got away with it. Because if they had said that, it clearly would have conflicted with Title VII, and then Title VII, the court would have had to rule that Title VII preempts it. Because where state law and federal law directly conflict, federal law preempts state law. So they would have had to rule that way, but the order didn't say that. It just didn't allow for religious exemption from the shot, but it didn't say no religious accommodations would be allowed. And so the Solicitor General here points that out and said, well, because it's not preempted, because it didn't directly conflict, didn't bar all kinds of religious accommodations, it just didn't allow for religious exemption to the COVID shot, technically it's not preempted, and therefore the hospitals were correct in using as their defense that it would be an undue hardship for them to grant an exemption from the COVID shot because they'd be violating state law. They said if it was preempted, you can't use that excuse. Where there's a direct conflict and federal law preempts state law, you can't use the excuse, well, we have to enforce the mandate. We can't allow exemptions because we'd be violating state law. No, federal law trumps state law. But here, since there's not a direct conflict, they could have offered other kinds of accommodations, such as, for instance, telemedicine. And they said the plaintiffs here didn't really explain whether they asked for that or whether that would be possible. The record's not really developed as to that. And so technically there were other alternatives they could have sought. They could have sought telemedicine or perhaps other working arrangements, maybe masking and testing, other things other than just a blanket, we want to be exempted because of our religion from receiving the COVID shot. And because because federal law Title VII does not require employers, and this is true, I've practiced in this area for years, because federal law does not require an employer to grant the accommodation the employee requests. You don't have to grant the preferred accommodation. You just have to grant some reasonable accommodation that accommodates the employee's religious beliefs and is not an undue hardship, substantial burden upon the employer. So they tried to say, well, it would be an undue hardship because we'd be violating state law, would get fined, sanctioned, whatever. And so you can't expect the employer to do that. And because there wasn't direct preemption here, they said that's a good defense. The hospitals are allowed to do that. Legally, technically, that may be correct, but there are other reasons that if I were writing as a Solicitor General, I would have asked the Supreme Court to take this up, to say, well, the decision they're relying on, though, is there's not just our decision, the We the Patriots decision, but other decisions as well at the Second Circuit that have already ruled in this mandate that were wrong for other reasons, that were wrong because, as the plaintiffs themselves asserted, and again, maybe they can argue that maybe it needs to be remanded to have the record developed better. But as the plaintiffs themselves asserted, it would be kind of illusory. I believe they asserted this anyway. That would be basically illusory to offer any other accommodation because no hospital really was offering that. And anyone who's a healthcare worker during COVID knows this, that in general, especially in the state of New York or states like New York, hospitals weren't offering other accommodations. There really weren't other options available. It's like, especially if you're like an ER nurse, think about it. You can't do telemedicine. What else are you going to do? It's either you're exempted from the shot or you're not. Maybe they could allow masking or testing, yes. But in many cases, they didn't. And it was just basically you either get the shot or not, or you're fired. And they request an exemption and say, nope, that would be an undue hardship because of state law, whatever. And so in practice, these employees had no other option. And that's the reality of it. And the decision is legally incorrect, in my opinion, by the Second Circuit, that, you cannot issue a mandate that doesn't allow for any kind of health mandate, health intervention, a vaccine mandate that does not allow for religious opt-out. So there are people with very strong religious beliefs. And there's a very clear basis with regard to the COVID shot, as with most shots. For instance, things like aborted fetal cells being used in the testing, development, production of these vaccinations, and people that have a very strong religious objection to abortion, they had a very clear basis, a rational basis for their religious belief that should have been honored, that should have been respected. So I don't believe that, I'm not saying I agree. I agree in the strictest legal sense if they're just saying we have to adhere to the Second Circuit precedent and, obviously the way the record was developed, then the Second Circuit. My mic got unplugged again there for a minute. I'm watching it, people. So maybe in the strictest legal sense, I can see what they're saying, but I would have expected more out of this administration. So personally, I don't think it was a great brief. Moving on to the last thing, the executive order issued by the Trump administration. And this I am going to try to share. There it is. All right. Sorry, still having microphone issues. Okay, hopefully everybody can hear this and see me. But this is the executive order that was issued on May 29th, realigning United States core childhood vaccine recommendations with best practices from peer developed countries. And you'll see, now this is great. This is what we saw. ACIP, the Advisory Committee on Immunization Practices, is part of the CDC that advises the CDC, that committee that advises the CDC on childhood vaccine recommendations. They recommended earlier this year, although it was struck down by a federal judge, but they did recommend that less childhood vaccines should be given to modify the schedule, the CDC childhood vaccination schedule, to mirror what's used in other developed nations like Denmark and other European nations. I think Germany might have been cited there, Sweden, and then even Japan was cited at one point, I believe, with regard to ACIP's recommendations, that we don't need to be giving so many shots to these kids at such a young age. I mean, really, if you look at the real science, probably most of these shots we shouldn't be giving, but certainly we should reduce the number. And there are significant safety concerns, and they're saying that we should be guided by that evidence, by that real peer-reviewed scientific evidence regarding vaccine safety and the vaccine safety data that's out there right now. And the United States should be following that. And so that's great. That part, I don't think anybody has a problem with. The issue people had is there was nothing here regarding specifically religious liberty for school children in these states that don't have religious exemptions. It simply said, if I scroll down, each executive department and agency shall ensure all actions, regulations, funding, and coverage related to child and adolescent immunizations align with the schedule recommended by ACIP and adopted by the CDC, including fulfilling all legal obligations with respect to parental authority, religious freedom, disability accommodations, and equal protection under the law. Now, that's the federal agencies have to respect that. It doesn't say states have to respect that. Again, because the federal government cannot direct the states to do that specifically. Why? Because if something is unconstitutional, if a law passed by a state government violates the U.S. Constitution, the correct body to address that is the court, the judicial branch. Courts strike down unconstitutional laws, not the White House, not the president, not Congress. Courts do, and ultimately the U.S. Supreme Court, if it gets that far. Courts strike down laws that are unconstitutional. So this has to be decided in the courts. And the 10th Amendment, again, prohibits the federal government from usurping state authority and from telling states which laws they can or cannot pass. Okay, so that's what the issue is here. We're coming back to the same problem as with the very first document I shared with you. Okay, the federal government does not have unilateral authority to usurp the jurisdiction of the states and states' rights and enacting their own laws. But if the state does enact something that's unconstitutional, there are consequences, and those consequences are decided in court, in a court of law. And so this is why it's so important to support litigation. So again, I'll bring you back to Mission 250 at the bottom of your screen. We have several lawsuits in defense of religious liberty and health freedom unfolding throughout the United States right now. We have a lawsuit for school religious exemptions in California that's still ongoing, one in Connecticut, two actually in Connecticut that are still ongoing, a state and a federal lawsuit, and then also one we're about to file in Maine, which has also lost its religious exemption. Now, since the Second Circuit covers both Connecticut and New York, and we have one already in California, so we have the Ninth Circuit, Second Circuit, and now this will be a case in the First Circuit. We'll have all three circuits covered with our litigation portfolio, all three circuits covered where the religious exemption for school vaccinations has been lost for children. So children and families have suffered far too long. This has been going on in California since 2015. We're talking about 11 years. 11 years without religious liberty for families in California. That's sickening. It's disgusting. And it's got to be stopped. It's got to be reversed. A lot of these kids have already grown up and graduated. They're already, out of school, or they had to be homeschooled, or had to flee the state. Families had to leave their homes. Families that had lived in California for generations had to uproot and leave the state, or they had to homeschool their kids. Their kids were excluded from extracurricular activities, sports. Horrible. And it's happened in New York, Connecticut, and Maine too, as well. And even West Virginia doesn't have a religious exemption yet. They've been fighting that. They've been battling that recently in the last year or two. But they didn't repeal it. They never had one to begin with. But it's sickening, really. And about 20% of the nation's population, when you add all those states together, does not have religious liberty when it comes to school vaccine mandates. Okay, so this isn't just about COVID. It's just not about what happened during those COVID years. Religious liberty being taken away for workers, employees, public accommodations out at restaurants and concerts and stuff like that. We saw our religious liberty being trampled on then. But this has been going on a lot longer for school children, for families, for parents and children in those states. So please help us continue to fight. Donate to Mission 250. We're trying to raise $250,000 by our nation's 250th birthday. You can make a donation again at wethepatriotsusa.org, or by sending a check to the address at the bottom of our webpage, our website. Just go onto our homepage and you'll see the address right at the bottom. If you have any questions or comments, drop them in the comment section. I kept this, the last video was over 40 minutes, 45, I think, almost. This one's only 26. So I kept it brief. I didn't feel the need to get into all of the nuts and bolts of the legal jargon in the brief, for instance. There's a lot to unpack there. If you have specific questions about it, fine. But basically what it all boils down to is, yes, in some ways, do people feel that MAHA has let us down? Yes, and I understand that sentiment. And in some ways, maybe they have. But a lot of what's being said is not true, that they're just completely ignoring the law and the Constitution. Because under the Constitution, we have a federal government of limited powers. That's what it boils down to. The federal government actually doesn't have the authority to do as much as we would want them to do when the people in power are on our side. And that's good, because as you saw during other presidential administrations, there's a lot of times in this country when the people in power are not on our side. And if they had the authority to just march into your home state and completely usurp whatever state laws you have, especially for people who live in so-called, free states, red states, that do strongly protect religious liberty and protect against medical mandates and vaccine mandates. I'm in the state of Idaho now. That's where We the Patriots USA is headquartered. We were in Connecticut, but we've been in Idaho since 2022. And, we have the Idaho Medical Freedom Act, which actually makes it illegal for any business or school to mandate medical interventions such as vaccines. So it's actually, vaccine mandates are banned here. Can you imagine if we had a president come in that was allowed to just completely nullify that law? We wouldn't want that. So we don't want the president to have that kind of authority. The way to strike down an unconstitutional law is through the courts. And that only legal decisions have staying power. Only legal decisions are going to last for decades or centuries. An executive order isn't lasting that long. An act of Congress might, maybe not though. Yeah, and there's a reason why they say it would take an act of Congress to do something. There's that saying, because that's, in some ways, almost an impossible climb. Not that getting a Supreme Court victory is easy, but an act of Congress there's a reason it has that reputation. Okay, it's very, very, very difficult getting, even people that you think would be on our side to support a bill like that. So anyway, I'm going to go now. Keep this under a half an hour. Thank you for watching and listening. And again, drop your comments and questions below. I'll be happy to answer them. God bless. Have a good day.